Hey everybody, it's Rebecca and Din and from Goldfarb and Lou, and we're going to talk about conservatorships, which is one of the more challenging areas of elder law for a variety of reasons. So I don't do any of the court stuff. I will try to work on everything before that. And Din is the one who handles all of our court matters. So do you want to give a brief overview as to what conservatorship is?
Right. So a conservatorship is a process by which a court appoints someone to make decisions for someone who's lost capacity. And so this person could have lost capacity because of an accident, or this person could have lost capacity due to age-related decline. So things like dementia, Alzheimer's. And so there are different types of conservatorships. But today, I think the focus is for folks who have lost capacity, but mostly in the realm of the elder law, where mom and dad, uncle, neighbor, is no longer able to take care of themselves or has been a victim of elder abuse.
And on my side of the non-court stuff, we do as much, and I know you do as well, to make sure people have their advance directives and powers of attorney. So the two parts of conservatorship are either conservatorship over the estate, over the money, or over the person, which is the advanced healthcare part of it. So you might need both, or you might just need over the person.
Right.
Or so, the estate.
Right. Right. So that, I would say, you pointing out an advanced healthcare directive and a power of attorney is definitely, that's the alternative to doing conservatorship. And so that would be part of the estate plan that you would want to have in place.
And I know we both educate our clients a lot on the estate planning side and the court side. So what I always share with people is, these documents, the advance directive and power of attorney should work until you pass away. But sometimes the person we're caring for refuses the help or refuses to listen to our suggestions and direction. And at that point, it may trigger a conservatorship, even if you have these documents.
Right.
And then in terms of the big picture, the process, kind of how long it takes.
So the conservatorship process starts by filing a petition. If there is an urgency, there's an emergency that you need to file a conservatorship, then we would be filing a temporary conservatorship, and then we would be filing a general conservatorship at the same time. So you have to file a general conservatorship if you file for a temporary. So you can't just do it for a temporary period of time, because a conservatorship lasts for the entirety of the conservatee's life. So that's definitely something to consider. And the conservatorship, you're looking at probably 2 weeks about for a hearing on the temporary. And then the permanent is probably around 4 or 5 months. And so in most cases, and in all cases of elder abuse, we will file a temporary and a general. But in most cases, there's going to be some urgency. So we do file a temporary with the general conservatorship.
And obviously, this is a public process. It's not done in secret, and it's very expensive. Do you want to touch upon those?
Right. It's expensive, and it's very public, and you air all your dirty laundry. So it's unfortunate, but the court has to be advised. And so these are public documents. They can't be redacted. And so one of the things that makes it so expensive as well is this, how much time it takes, how many phone calls and appearances and briefs and filings it takes. One of the interesting parts, especially in LA County, is that you're appointed, and I believe it's the law in California, but in LA County, you're appointed a private attorney. And in Orange County, it's the public defender's office, right? So in in LA County, you have this private attorney who then represents the conservatee. And so let's just say, Rebecca, that your mom needed a conservatorship, right? She would actually be given her own attorney. So if you hired us, I would represent you as the conservator, whether it's the conservator of the person or the estate. And then upon the filing of the petition, the CAC, the court appointed attorney, is also appointed as your mom's attorney. And it's a very interesting thing having a CAC that you're working with who has to advocate for the wishes of the prospective conservatee rather than what is in their best interest. And it's definitely I've worked with a lot of CACs. They used to be called PVP. So if you hear PVP, it's the same thing as CAC. And a lot of the time goes into working with the CAC.
And some of them are great, and some of them are very challenging.
Yes.
Yeah.
These are panel attorneys. And so it just, there's so many differences of personalities and different experience levels. And so you deal with a lot of people when you're dealing with a conservatorship. And besides the CAC, I think another reason it costs so much is when you have family, and especially if there are family dynamics that you're working within, particularly where there is fraud or undue influence. And so, but I do have cases where we're just trying to conserve an elderly person who is unable to let go, right? They've got like the last vestiges of like control. And sometimes those are really hard as well. So
there's a lot of emotion that goes
mm-hmm.
to these conservatorships, whether it's on the petitioner side, who's usually a family member, or
Mm-hmm.
it's the actual elder who
Mm-hmm.
doesn't want any of this. Usually,
Right.
it depends how far along they are.
Right. And there's also one other category when you have family fighting family,
Right.
Different family members fighting to become the conservator to control mom or dad's estate and then person. So it can get really intense. So
very messy.
yeah, that's why it takes a lot of time. And so, we charge it based on our hourly. Of course, if we don't get paid until the very end, but we ask for a retainer of about $4,000, and that pays for costs and for the most part. But until the conservator is appointed, right, and the first counting is done, that might be a year and a half until we get paid.
Right.
So,
and I know, because you and I have talked about this so many times, that it's the last resort, that some attorneys just immediately default to a conservatorship. And
right.
you and I have strategized so many times for clients about how do we avoid it? Is there anything outside of the box we can come up with?
Right. It's so that you say that, because every single time someone calls, I am telling them, and I'm like, please, let's just figure out what we can do. And I try to steer people away from conservatorships. And unless there's another viable alternative, I am looking at all different avenues to avoid a conservatorship. It's really burdensome. It's very expensive, and it lasts the conservatee's whole life. And so, one of the things also I forgot to mention in terms of costs is there's an accounting requirement when there's an estate. And so an estate, I think the idea of an estate is like, oh, there's a lot of wealth, but that's not true. An estate just means you have stuff. And so whether it's a house, it's a pension,
right,
an annuity, and a couple bank accounts or an investment account. The conservator has to account for every single penny that is spent. So,
and you're doing this annually. It's not just up front. You're continually.
The first year you do it, and then it's every 2 years.
But you're still accounting for all the money throughout that time.
Yeah. And so it's, when we're off by like 6 cents, I want to kill myself.
I've heard this before.
Yeah.
So obviously, we're educating our clients and really working to avoid a conservatorship
Mhm.
when possible. And then sometimes we can't avoid it. So clearly we do this in the most compassionate, most ethical way. Um,
Mhm.
and before we end, do you want to just quickly talk about the capacity declaration uh,
Okay.
part?
Yeah. That is probably one of the most critical aspects in setting up a conservatorship. It's um, a doctor, a neurologist, a geriatric specialist, someone other than the family,
Yeah, this is
or
not what the family is deciding, because most family members say, no, 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 they're fine. They totally
Mhm.
understand. And it's
Right.
not
Um,
based on how we think, it's based on an evaluation by a physician or
exactly.
a
Mhm.
psychologist.
Right. Because the court has to make a finding that this person lacks the capacity. And so if we have the doctor, making this determination, that's the only way the court then can make its own findings. And so without a capacity declaration, it is virtually impossible to get a conservatorship. And so I can't tell you how important it is to be able to establish a relationship with the physician and get that physician to put down in writing. There have been physicians who have outright refused to do declarations. And
And then we have to hire a specialist, and that costs
Mhm.
thousands more.
Exactly. So,
Yeah. Well, thank you. And for everybody watching, I hope this answers some of your questions.
and
And
scares you because it is not something that we go into lightly. So,
And so, for everyone make sure that you share this knowledge about the advanced directive and power of attorney. Your spouse does not get to make decisions for you. You don't get to make it for your 18-year-old client, and you don't get to make it for your aging relative. So, it is so important to get these done. I think conservatorship is by far worse than probate. Um,
oh, I mean, I don't. I mean, in a probate, the person's passed away, so there isn't like an urgency. But conservatorships, it's very emotional
yeah,
and just it's hard. Conservatorships are hard.
absolutely.
Hmm.
All right. Well, thank you, and I guess that's it. So take care, everybody.
Bye.
Bye.